Hello, everybody. Hello, welcome in. Good to see you. Good afternoon or good morning, depending on where you're at in the world. Good morning. Hello, James. Hello. Oh, yes, had to jump on for sure. Hello. Oh, hello, Kaya. Good to see you, Michael. Oh, really? Oh, oh dear. Hello, Lisa. Hello, Michael. Also good to see you as well. Yes. Well, hi, Karen. Good to see you. Oh my goodness, everybody. This order. Oh my goodness. It's just really, it's very interesting. I think it's very interesting. It starts out like a normal order does, and I will read through it word for word. But then he kind of brings the fire. He's kind of mad. So Judge Rashawn's, he's kind of mad about the situation. So he explains, why we have fines in the situation, why he decided to do what he did. He explains it very well, and I think in a very good way, to set it up for if he does order jail time for grounds, sets it up in case it needs to be appealed. So I thought he did great. Had a feeling I'd be on. Yes. Oh, it's a good, it's a very interesting order. Yes. I know we've all been waiting. For the level of, I think we're all waiting for the sanction to fit what has been done. And I think from the outside looking in, we always think, well, he's a billionaire, or so to speak, allegedly. So, a little fine like this isn't going to be sufficient. But Judge Mershon explains why he set the fine the way that he did and what he would have liked to have done. So I thought he did a pretty good job. Could he order house arrest? No, I don't believe so, Lisa. Great question. No, he's, under the code section that they're using here for contempt in New York, he's pretty limited actually in what he can do for contempt. Now, once there's a guilty verdict of someone, what can happen for sentencing, that's a whole different ballgame. There are lots of options, but for this particular contempt issue, the way it's been charged, there just are not a lot of options. So he may need to borrow money. Oh, I know. I know. Oh, my goodness gracious. Lee follows through. Well, the thing about Judge Mershon is that I've yet to see where he hasn't followed through. So we've had a couple of situations, and I know what you're talking about. We've had a couple of situations, I think, with Judge Engeron that I can think of where he set out an order and then kind of not didn't really backtrack on it, but just was like, whatever, let's keep going. But I don't think Judge Mershon is that way in this case. He has been very strict. And also, Judge Engeron, it was a civil case. So this is really our first true criminal case where we're seeing a judge in a criminal case kind of say, we've got rules here we've got to follow. So CDAG charge federal crime. Not a stupid question. You have to have a federal prosecutor charge a federal crime. So because we're at two tiers, we have the state level and then we have the federal level. But the Attorney General is representing a state, which could also lead to a federal case being filed because of how our diversity jurisdiction works. So if we've got multiple states involved, that can be filed differently. So if it's for a charge in your state, the AG is going to be able to charge it. But if it's a state against another state or a state against a corporation, something like that, the AG can pull those kinds of cases. Oh dear. Oh no. Oh no. Oh my goodness gracious. No, Melania, save yourself. No. I have no doubt Melania is taking very good care of herself. So So we'll see. We are in week 3, everyone, of the trial in New York. This is the falsifying business records to cover up hush money payments, to cover up a catch and kill scheme in order to, inappropriately influenced the 2016 election. I think I got all the categories there. I think I got all the categories. So let's go ahead and dive in, everybody. Welcome in, welcome in. Now, I did give a little, sneak peek into this, and we are dealing with fines, but keep in mind the state has only asked for fines, and that's okay. The state can ask for what they think is the best approach in the situation. When we're dealing with contempt, keep in mind also, everybody, the goal is to get the defendant or the violator to follow the rules. That's the goal. The goal isn't to put the defendant in jail. That is not the goal. I know, everybody wants that to be the goal, but that's not the goal. The goal is to get Mr. Trump to comply with the judge's order. And so what's happened here is going to be what the judge thinks needs to happen in order to get Mr. Trump to come into compliance with his order. Now, the state had set out fines. That's what they had requested. The judge has his own way of looking at it as well, which we will go through. But just keep in mind here that our goal, again, is to get Mr. Trump to comply with the court order. All right? So, and that has got a lot of different ways that it can be gone about. So let's go ahead and take a look here. I will just read through the order and do kind of a Q&A right after to kind of explain things. I think the judge did a really great job. It's not a long order, but it's also, I think it's adequate. It's just the right number of pages. So let's go ahead and get started, everyone, and I'll read through and then we'll do a Q&A after. So we have here decision in order on the people's motion for contempt. I did do a live and I have posted different pieces of that live going through that contempt hearing for those who have been interested. So here we go. Judge Juan Merchan, here's the background. So I've got my little sticky note down here for people who are just joining us. All right, background. Defendant is charged with 34 counts of falsifying business records in the first degree in violation of Penal Law Section 175.10. The charges arise from allegations that defendant attempted to conceal an illegal scheme to influence the 2016 presidential election. Specifically, the people claim that the defendant directed an attorney who worked for his company to pay $130,000 to an adult film actress shortly before the election to prevent her from publicizing an alleged encounter with defendant. It is further alleged that defendant thereafter reimbursed the attorney for the payments through a series of checks and caused business records associated with the repayments to be falsified to conceal his criminal conduct. Trial on this matter commenced April 15th of 2024. On February 22nd of 2024, the people filed a motion for an order restricting extrajudicial statements by defendant. On March 26th of 2024, this court granted the people's motion and issued an order hereinafter the order. On March 28th of 2024, the people filed a pre-motion letter seeking clarification or confirmation of the March 26 order as to whether it proscribes extrajudicial speech against family members of the court, the district attorney, and all other individuals mentioned in the order. On April 1st of 2024, the court issued an order expanding the restrictions contained in the March 26, 2024 order. Order hereinafter the expanded order. Defendant sought an emergency stay of the expanded order from the Appellate Division, 1st Department, which was denied on April 9th of 2024. Footnote 1 states, the first of 10 alleged violations occurred the following day on April 10th of 2024. So the day after they denied his appeal was when the first allegation occurred, alleged violation. On April 15th of 2024, the people moved by order to show cause for this court to find defendant in criminal contempt for allegedly willfully violating the expanded order on 3 separate occasions. This is their first request, was a batch of 3. Defendant was served with the signed order to show cause the same day in court. On April 18th, the people again moved by order to show cause for this court to find defendant in criminal contempt for allegedly willfully violating the expanded order on 7 additional occasions. So that's how we get to 10, everyone. Defendant was served with the second signed order to show cause in court that same day, and he filed answering papers on or about April 19th of 2024. A hearing was conducted on April 23rd of 2024. The people seek a $1,000 fine for each of the alleged violations pursuant to Judiciary Law, Section 751. The people also ask this court order the defendant to remove the 8 offending posts from the defendant's Truth Social account and the 2 offending posts from his campaign website. Lastly, the people request that the court, quote, warn the defendant that this conduct will not be tolerated and remind him that incarceration is an option should it be necessary, end quote. And that's a side of the transcript from that hearing. The language of the expanded order that is pertinent to the instant motion is, so here's the law that we are looking at. Ordered that this court's order on March 26th of 2024 is amended to indicate, as indicated below, defendant is directed to refrain from making or directing others to make public statements about known or reasonably foreseeable witnesses concerning their potential participation in the investigation or in this criminal proceeding. B, making or directing others to make public statements about 1, counsel in the case other than the district attorney, 2, members of the court staff and the district attorney's staff, or 3, the family members of any counsel, staff member, the court, or the district attorney, if those statements are made with the intent to materially interfere with or to cause others to materially interfere with counsel's or staff's work in this criminal case, or with the knowledge that such interference is likely to result. And making or directing others to make public statements about any prospective juror or any juror in this criminal proceeding. Right, so you can go online and just put in Trump Contempt Order New York, and it should pull it up. You should be able to find the PDF that way. There's lots of different sites that have linked it, so I can't give you a specific site. It'll just depend on your jurisdiction, wherever you're at, what comes up when you pull up your search engine. But it's readily available, unlike a lot of the stuff in the New York cases. So this one is easily findable. Findings of fact is the first piece. Oh, by the way, we probably could go onto the New York court's website, and if you go to their press piece, they actually have a little category just for this Trump trial. They may have this order up. Some orders they have up, some orders they don't, so it depends. All right, findings of fact, everybody. So these are true findings of fact. The judge is the fact finder here, and so this is what he has found to be true. This court has considered the respective arguments of both parties, the exhibits introduced into evidence at the hearing, and all submissions filed in support of and in opposition to the motion for contempt. The people claim the defendant has violated the expanded order 10 times. The alleged violations were introduced into evidence at the hearing as Peoples 1 through 10 as follows. So we've got a footnote number 2 here, and he's explaining this as well. The people also introduced into evidence exhibits 11 through 15, which were not offered as violations of the expanded order, but rather to advance the people's argument that the defendant's conduct was willful. So he's just setting his record straight here. Again, if there's any kind of appealable issue going on after the order's done. The people here, so we've got 1 through 10. Let me make sure I've hit that footnote. So Exhibit 1 was a post on Truth Social, April 10th, 10:07 a.m. Exhibit 2, Truth Social post, April 10th, 10:48 a.m. Exhibit 3, Truth Social post, April 13th, 12:56 p.m. Exhibit 4, Truth Social post, April 15th, 9:12 a.m. Exhibit 5, Truth Social post, April 15th at 10:26 a.m. Exhibit 6, a post on defendant's campaign website on April 15th. Exhibit 7, a post on Truth Social, April 16th at 1:50 p.m. Exhibit 8, a post on the defendant's campaign website on April 16th. Exhibit 9, Truth Social post, April 16th at 7:09 p.m. And Exhibit 10, a post on Truth Social, April 17th at 5:46 p.m. So each one of these, they were asking for a $1,000 fine. The 10 posts consist of posts made by the defendant, a repost of material previously posted by another source on another website or social media account, which also contains defendant's words, and reposts of material previously posted by another source on another website or social media account which do not contain commentary by the defendant. So we have Exhibit 1, and then we have Exhibits 4, 5, 6, 7, 8, and 9. Defendant does not dispute that he either posted or reposted all 10 of the posts in question. Rather, he advances several defenses to support his claim that his actions do not constitute a willful violation of the expanded order and that he should therefore not be found in criminal contempt. Just a friendly reminder to everyone, the contempt he was found in, or the sanctions he had from Judge Engeron, were for civil cases. So we got to keep that in mind as well. He argues, for example, that reposting another's post does not violate the expanded order because the words are not his own, but those of someone else that he believes reposting was permissible because the people and the court did not move to enforce the expanded order after the first repost, and he did not willfully violate the expanded order because the post constituted protected political speech made in response to attacks by Michael Cohen and Stormy Daniels. Then we have footnote 4 here. At the hearing, the court gave defense counsel numerous opportunities to cite actual instances where the defendant's posts were made in response to perceived attacks by protected witnesses. Aside from referencing a tweet in their responsive papers relating to Exhibit 1, counsel was unable to direct the court's attention to any other specific attacks by the protected witnesses, which immediately preceded defendant's posts. Defendant offered no exhibits at the hearing. So this is a point that Judge Mershon was very upset about during the hearing. He kept asking, where's your proof, where's your evidence, or point me to it. So here's our conclusions of law. The judiciary law authorizes a court to hold a party in criminal contempt for willful disobedience of a court's lawful mandate. Here in reciting case law. This is to protect the dignity of the judicial system and to compel respect for its mandates. Further case law here in New York, and to punish the contemner for disobeying a court order. Criminal contempt requires a showing of willfulness on the part of the contemner, which must be proven beyond a reasonable doubt. Thus, for a court to make a finding of criminal contempt, the moving party must establish 1, the existence of a lawful order expressing an unequivocal mandate, and 2, a violation of the order, 3, that is made with knowledge and is willful, quote, a party may not challenge a court's order by violating it, end quote. And then we're citing further case law. Indeed, a party may be held in contempt for violating an order later found to be unlawful. An adjudication of the contempt occurs at a plenary hearing with due process of law, including notice, written charges, assistance of counsel, compulsory process for production of evidence, and an opportunity to the accused to confront witnesses against him. This is New York law setting that out. A plenary hearing, as required by law, was conducted April 23rd of 2024. Discussion. This court rejects defendant's arguments and finds that the people have established the elements of criminal contempt beyond a reasonable doubt as to Exhibits 2 through 10. So Exhibit 1 is not included, everyone, right? Keep that in mind. This court's expanded order is lawful and unambiguous. Defendant violated the order by making social media. Hello, Mads. Good to see you. Posts about known witnesses pertaining to their participation in criminal proceedings and by making public statements about jurors in the criminal proceeding. Addressing first what has been referred to as reposts, Exhibits 1, 4, 5, 6, 7, 8, and 9, this court finds that a repost, whether with or without commentary by the defendant, is in fact a statement of the defendant. The issue of reposting appears to be a question of first impression. Lacking legal authority to guide its decision, this court must, as defense counsel stated at the hearing, rely on common sense, which is another really hard-hitting moment that Judge Mershon had during the hearing that was very frustrating to him, I think, as well. Like, I am using common sense. Both the Truth Social account and the official campaign website exclusively represent the opinions and views of the defendant, and neither is an open forum for others to post their own content. Defendant curated the posts at issue and then took the necessary steps to publish the posts on his Truth Social account and on his campaign website. In doing so, he endorsed the posts with one purpose in mind, to maximize viewership and to communicate his stamp of approval. Indeed, defendant has boasted about the reach of his Truth Social platform when describing its value. Quote, "More importantly, Truth Social is a primary way I get the word out, and, for better or for worse, people want to hear what I have to say. Perhaps, according to experts, more than anyone in the world. On Truth, I have 7 million followers." End quote. And that's according to Exhibit 11. "When I put out a statement, it is spread all over the place, fast and furious. Everybody seems to get whatever I have to say, and quickly. If it doesn't work or properly get the word out, I wouldn't use it. But it does work, and work really well." Again, quoting Exhibit 11. Thus, there can be no doubt whatsoever the defendant's intent and purpose when reposting is to communicate to his audience that he endorses and adopts the posted statement as his own. It is counterintuitive and indeed absurd to read the expanded order to not proscribe statements that defendant intentionally selected and published to maximize exposure. This is not to say, could you slide the paper over to the left? Sure, absolutely. There we go. There we go. Is that better? I'm glad you told me. Yep. Okay. Excellent. Okay, good. Phew. You bet. Sometimes the paper slides as I'm going through everyone. So let's back up here. So it is counterintuitive and indeed absurd to read the expanded order to not proscribe statements that defendant intentionally selected and published to maximize exposure. This is not to say the repost will always be deemed a statement of the reposter, as context is directly relevant. However, here, under the unique facts and circumstances of this case, the only credible finding is that the reposts constitute statements of the defendant. Turning next to the defendant's post, in which he purports to quote Jesse Waters. Exhibit 10. This is not a repost, but rather the defendant's own words. Mr. Waters uttered a statement which defendant altered, placed in quotes, attributed to Mr. Waters, and posted. The purpose being to call into question the legitimacy of the jury selection process in the case. This constitutes a clear violation of the expanded order and requires no further analysis. Okay. Defendant next argues that the statements contained in the exhibits were all made in response to political attacks. While the expanded order does permit defendant to respond to political attacks, merely characterizing every one of the defendant's posting as a response to a political attack does not make them so. Although defendant did not produce any exhibits at the hearing, he did refer to two postings contained in his opposition papers. They include a post by Michael Cohen on April 9th of 2024, wherein he comments on those who support defendant for the presidency, and a second post by Michael Cohen on April 10th of 2024, referencing Michael Avenatti's likelihood of receiving a pardon from Donald Trump. While it remains unclear whether Exhibit 1 is in fact a response to these two posts, the tenuous correlation is sufficient to give this court pause as to whether the people have met their burden as to the exhibit. This is why Exhibit 1 was kicked out. However, that cannot be said as to the remaining exhibits, Exhibits 2 through 9, which attack the credibility of arguably two of the more high-profile witnesses in this case. To allow such attacks upon protected witnesses with blanket assertions that they are all responses to political attacks would be an exception that swallowed the rule. The expanded order does not contain such an exception. To pause here for a tea break, everyone. Just one moment. At the same time, this court is keenly aware of the protective of defendant's First Amendment rights, particularly given his candidacy for office of the President of the United States. It is critically important that the defendant's legitimate free speech rights not be curtailed, and that he be able to fully campaign for the office which he seeks, and that he be able to respond and defend himself against political attacks. For that reason, this court exercised discretion when it crafted the expanded order and delayed issuing it until the eve of trial. The order is narrowly tailored to prevent risk to the fair administration of justice and is clearly and unambiguously identifies the limited way in which defendant's speech is restricted. It is of the utmost importance to this court that the expanded order not be used as a sword instead of a shield by potential witnesses. Consideration of such usage will be weighed by this court when ruling on the willfulness of any future claims of alleged violations of the expanded order, as well as when determining appropriate punishment, if any. In fact, the court may very well consider the propriety of continuing the limitation on extrajudicial speech as it relates to certain individuals. As this court observed, in the expanded order, it remains this court's fundamental responsibility to protect the integrity of the criminal process and to control disruptive influence in the courtroom. Citing case law here. The underlying purpose of the restriction on extrajudicial statements is to protect the integrity of these proceedings by shielding those fearful of reprisal by defendant so that they may take part in these proceedings without concern. However, if a protected party turns that underlying purpose on its head, so this is the warning he's giving everyone. Are you hearing the warning in here? Here's the warning. If one of the witnesses that this is intended to protect turns the underlying purpose on its head, it becomes apparent that the protected party likely does not need to be protected by the expanded order. Ooh, hello. I wonder, this is for Mr. Cohen. Mr. Cohen, you're not going to be included in the order if you don't calm down. All right, the court is cognizant that the defendant has made, through the various motions he has filed during the pendency of this case, numerous references to the commentary of Michael Cohen and Stormy Daniels, and, as indicated above, will consider such in any future filings. Nonetheless, the court finds that it is not yet necessary to modify the terms of the expanded order to exclude any of the currently protected parties. The court finds defendant in criminal contempt of willfully disobeying a lawful mandate of this court in violation of the Judiciary Law Section 750 sub 3 on 9 separate occasions. Punishment and order. So this is where we're setting it out here. He would no longer discuss. And this was a response to written things that he had done. So I'm not sure how his lives are going to go with that. All right, punishment and order, everyone. Again, friendly reminder, contempt is to get the defendant to follow the rules. The goal is not to just put somebody in jail. So bear with me on that, all right? Criminal contempt is punishable by a fine not exceeding $1,000. So that's the limit. So the state asked for the maximum fine on each charge, all right? And by jail not exceeding 30 days or by both in the discretion of the court for each violation of the court order. So let's break that down. We had 10 violations, right? So that would be a total of $10,000. And then we had 30 days. That could be 30 days per violation. So that could be 10 sets of 30 days. So this could be a year, up to a year in jail for his contempt. So let's keep that in mind. Also, let's put that into consideration as well. 30 days per violation. Now, there are situations where I have seen judges do 30 days, 3 or 4 times in a row so that someone is in jail for a couple of months. That would be pretty atrocious. 9 counts, right. Thank you very much. Appreciate that, Josh. 9 counts. We'll go back. Here we go. 9 because Exhibit 1, we weren't sure. So 9 counts. All right, so 30 days each. So up to 9 times 30, all right? 10's easier to math. The judiciary law permits this punishment to protect the dignity of the judicial system and to compel respect for its mandates, citing case law, and to punish the contemptor for disobeying a court order. So there is a punishment element to it, right? But we have to compel respect. Next, it says, however, the judiciary law does not vest the court with authority to craft an appropriate punishment when a $1,000 fine will not achieve the intended purpose. So Judge Mershon is saying this $1,000 fine is not going to do what we need it to do here. So he's acknowledging it right here, all right? He's saying your $1,000 fine max isn't going to cut it. While $1,000 may suffice in most instances to protect the dignity of the judicial system, to compel respect for its mandates, and to punish the offender for disobeying a court order, it unfortunately will not achieve the desired result in those instances where the contemptor can easily afford such a fine. In those circumstances, it would be preferable if the court could impose a fine more commensurate with the wealth of the contemptor. In some cases, that might be a $2,500 fine, or in other cases, it might be a fine of $150,000. So he's noting right here, that he would have liked to have given a higher fine based off of what would be more appropriate, but he is restricted by what the law says here. Because the court is not cloaked with such discretion, it must therefore consider whether in some instances jail may be a necessary punishment. So because he cannot get a high enough fine, he is saying jail may be the next punishment. So he's really setting this out pretty strong. He's saying right now we're going to do fines, but I don't think the fines are going to be high enough, so jail is my only alternative. So this is a pretty significant warning shot. Therefore, defendant is hereby warned that the court will not tolerate continued willful violations of its lawful orders, and that if necessary and appropriate under the circumstances, it will impose an incarceratory punishment, and it is hereby ordered. So he's saying right here, if we have another violation, incarceration is on the table. Now, we all know Mr. Trump's kind of been going back and forth, and there have been questions of, is he trying to get put into jail? Is he not? At this point, Judge Merchan has said very clearly, here you go. I gave you your fines. I gave you your situation that I would normally give to anyone on a first-time contempt. But if it happens again, fines aren't going to be high enough. You will go to jail. So this is it. Ordered that defendant pay a $1,000 fine for each of the 9 violations of this court's lawful order by the close of business on Friday, May 3rd. And it is further ordered that the defendant remove the 7 offending posts from defendant's True Social account and the 2 offending posts from his campaign website by 2:15 Tuesday, April 30th. So 2:15 p.m., the foregoing constitutes the decision and order of the court. Signed, Juan Merchan, April 30th, everyone. Second motion. I'm not sure. Because I'm not sure what he's going to do. That this order has come out, but we are due tomorrow, is my understanding. Oh, wait, Wednesday. It was set for Wednesday, but then it got moved to Thursday. We're set for another contempt hearing on Thursday, everybody. We are set. The prosecutor has come in and has said that. Was the contempt hearing today? Yeah, that was my understanding, is that it was set. I have not seen any postings on that. Yeah, we're supposed to have a hearing on Thursday regarding more violations. I was so confused when it came in this morning. Really, VC? Was it? Okay. So was it this morning then? Did they already hold it this morning? No court tomorrow. What's the motion filed? It's set for Thursday. Right, Pam, that's my understanding. Are we set for Thursday? VC, help me out. VC, Mads, come on. I know y'all are out there. No, okay, it was today. You're my eyes and ears while I'm highlighting all my stuff. So does this mean jail could be on the table for the second hearing? Yes, it's the second one. Okay. They didn't hold it today. Okay, thank you. All right, everybody, let's take a moment, stepping back. So my understanding, I'm not sure what the hearing was for today. This order was issued today. There is a second contempt hearing. So another contempt hearing set for this Thursday. All right, everybody? Thursday morning, we have another contempt hearing. This order has now been issued. So he is saying, if I've got another contempt hearing and I find you have violated, I'm going to put you in jail. But the violations for Thursday's hearings occurred before this order came out. So I'm not sure about the timing on it. I'm not sure how the timing will work. So that's where I was mixed up. Oh yeah, no, I mean, I'm mixed up too, VC. Oh my gosh, there's so much going on. There's just so much going on. So this Thursday, we have no court, by the way, tomorrow, which is Wednesday, because Judge Merchan is in a different court. Thursday, we are back in court after today. So they'll have the rest of testimony for today. And then Wednesday, no court. And then Thursday, we're back. And Thursday is the hearing for the second batch. He's always known jail was a possibility. I agree. I think it's also important that to note that Judge Mershon issued this order today. He issued this order today, 2 days in advance of that hearing. So everyone's kind of got notice now. Technically, under this order, if he is found in contempt again, Judge Mershon is saying a fine isn't going to be enough. So what's he going to be able to do on the Thursday hearing? If he finds him in contempt again, when this order has come out, his only recourse will be pretrial release. So the pretrial release situation is just not being played. That angle's not being played. It can be played, but it's not being played at this point. And I think it's because Judge Mershon is really wanting Mr. Trump to be coming to trial, but not having to deal with him being full-time in jail for the entire part. If they revoked his bond and put him in jail, he would be in jail for the rest of the entire situation. Bailing him to say, well, I think he might be baiting him too, Mads. So, all right, everybody, let's break it down. So we've got two roads. We've got two roads on Thursday. Road number one, we have a fine situation because the acts were prior to this order. All right, that's road number one. And then we have road number two. If he's found in contempt, then he goes to jail. All right, those are our two roads. It will depend on how the judge wants to deal with it, because he is setting out in this order, fines aren't enough. So from this moment forward, we're going to be looking at incarceration. But this moment is April 30th, and the Thursday hearing is regarding acts prior to this. All right? Now, prior to this, but on the other hand, this order is prior to a finding of contempt. And he didn't say that it had to be after this order. That's not set out in this order. So when it's a finding of contempt, it's possible that it could be jail. It will depend on the timing, how Judge Mershon wants to see the timing on this. Yeah, it depends on the timing, all right? So it could be fines again with a situation like, wow, this was filed before my order was issued. These were done before you realized incarceration was an issue. I just don't see how that would work, though, honestly. Judge Mershon has been so clear that jail was on the table. So clear. And so even though the acts were done before, I just don't see him going down that road. And then alternatively, we've got jail. So jail is absolutely on the table at this point. Jail is on the table, and as early as Thursday. All right. Now, keep in mind, we had this hearing several days ago, and it took several days for the judge to issue this order. So if we have the hearing on Thursday, the judge can take it under advisement and then come back with an order. So it might be as late as next week, early next week. I find it frustrating. They make a lot of threats and they do nothing. It feels that way because of how careful our timing is in the system. All right, so I get what you're saying. But we have an order here where a judge is clearly saying, at this point, it will be incarceration for violations. The only thing we don't know if it's for violations that occurred before or after this order. That's the only thing we don't know. But the fact that jail is what he's talking about here, I think is very clear. For Judge Mershon to come in and say, I'm going to put you in jail for violations. So if Mr. Trump violates it today, let's just take the time out of the equation. Let's take it out. If he violates it today and the state decides to bundle it in on Thursday's hearing, because any contempt situations between now and Thursday, the state could just add it to Thursday's hearings. So now we have half before the order and half after. See how the timing is kind of odd here? How many acts of contempt are coming up this round? I have to review the petition. I've not read it. I know there are multiple, but even if it's a mixed bag. So what's the judge going to do? Like the ones before the order, just fines. The ones after the order has to be jail. Or is the judge going to say, I don't care when they happened. In my order, I said if you're found in contempt again, you're going to go to jail. So it doesn't matter when the acts were. What matters is when you're found in contempt, which could be on Thursday. So the timing in the legal system that's our whole lives. We live and die by the time. And it's not that the judge is saying, well, I'm going to let you go. No, it has to do with the very specific timing of when the acts occurred versus when the order was put out. Because anything done after this order is jail. That's the order. And so the judge would be going back on his own court order if he did not put incarceration in for a violation after this order. Right. So I have no doubt that Judge Mershon has just set this out and said, we're done. I don't know if he has exactly how things will break down on Thursday. Again, we'll have to get a clear view of that because it's just not stated in here. Yes, 2:15 is the deadline here. So here's let's look specifically to the language in the order that the judge wrote. So of course he has to be in compliance with it. Defendant is hereby warned that the court will not tolerate continued willful violations of its lawful orders, and that if necessary and appropriate under the circumstances, it will impose an incarceratory punishment. That's all he has said. So for the hearing that's coming up on Thursday, all he is saying here is if we have continued willful violations. So, that might be said as, we've got a finding, then he could go to jail. This would be something that would be an appealable issue. This would be appealable by defense. So we don't know exactly how it's going to go down because we have this pending situation. We don't know if there are going to be more violations added to it. So we're kind of in a 50-50. 50 before the order, 50% after the order. And we'll see how that goes as well. But we're so careful with our timing on everything. Now, a lot of people, I wanted to ask this question too. Many people are saying judges are going back on their word, or they're taking back what they say, or they're not following through. So let me ask the chat, give me an example. Give me an example of what you mean when they're saying a judge is not following through. Let's just hash it out. Let's hash it out. When do we have a situation in any of the Trump cases when a judge is not following through? Give me an example. Oh, absolutely. Oh, my pleasure. Absolutely. Oh, I'm happy to. This is a really interesting area, actually, of the law, the whole contempt process, criminal versus civil. Reported by CNN, broke the gag order this morning. Okay, well, and he has to be charged. Now, this has to be brought up by the state. So the state has to bring it in front of the judge. The judge cannot go out on his own and bring it. He has to respond to a motion. Being he's an ex-president, I think it's a gag order. Judge is corrupt. Well, give me an example. Appeals delay sentencing. True. Appeals can delay sentencing, but we've been doing this for a really, really long time and a lot of appeals, so no more than usual, I wouldn't think. Does this finding of criminal contempt violate the terms of his release in other cases? No, Josh, great question. No, our jurisdictions don't cross over like that. They run parallel. They don't cross. Probably cite something Cannon has done by just failing to move the case forward. Fair enough. I think that's a great point, Mads. So let's talk about that for a second. Let's just talk about it. We have, what order would Cannon have issued where she would have given an order to Trump's team and then when it came time to enforce it, said, well, forget about it. So first we would need an order telling them to do something, and then we would need her saying, never mind on that order. Never mind. That's what we would need. We don't, and looking through the docket as I have with Florida, I do not know of an order where she has done that. I do not know of a single judge, all right, I'm going to spell Judge Chutkin's name incorrectly every time, where we have an order, all right, and we went back and we did never mind. The only thing I can think of here is with the gag order situation, where she put the gag order into place and then paused it to get the language right and then put it back into place. That's the only thing I can think of. Is that what people are thinking of, is the gag order situation in stayed their rulings? Stayed their rulings. The fines in New York's order to pay and then went down. Right, but that was the appellate court. And the appellate court didn't say you're not right. They just took 450 and moved it down to 175. I mean, and this is like million, right? So they cut the amount of money in half. So they didn't go back on anything. They just cut the amount of damages. Yes, the gag order. Okay, the gag order. All right, so, okay. Right, so let's talk about that for a minute. The gag order in DC is what Judge Mershon is allowed now to use for the basis of his gag order. It was because the gag order was appealed and checked by the Court of Appeals and sent back down so that Chutkan could implement it. There was a period where she issued it and then she paused it for about, I think, 4 days until it went through the proper appellate process, came back down, and then it was issued. So we had a 4-day delay, but it was not revoked. It was not revoked. It was delayed by 4 days. Oh, yes, the Supreme Court. Well, convinced he's... Does the Florida case still have a speedy trial start date? Yes, it does. That there has not been an order changing that. Would jail be appealable if it's an available punishment for any single count of contempt? It's possible. I think anytime your freedom's at risk, you have a chance to appeal through the process. Yep, delay. Right. Now, so then my question is, again, I'm just trying to get a read, everybody, on where we have this idea that judges are just going back on their orders. So are we feeling then, if there is a delay put in place by a judge, then that they are not enforcing their orders? Is that what we mean? No enforcement? Is that where we're getting this ideology from, this negative feeling? I'm just trying to kind of hash it out. If we have a delay, the order's still good, but we have a delay. And is that making people feel like it's not being enforced? Yes, he's not being held accountable. Okay, so, yes. Okay, that's exactly what I would say. Okay. Has not been making orders though. Well, right, canon, ugh. I mean, don't get me wrong. I just mean canon's process right now is so, it's so raw and what's the word I'm looking for? It's not very polished. It's what I'm trying to say. Okay. All right. Supreme Court. Right. All right. So, okay. I get it. So it's the delay process. All right. So I think then our overall issue here is the issue with delay. So some of the questions would be, why are the courts delaying it? Is it because Mr. Trump is special? Is this why it's delayed? And then does this happen to other defendants? Okay, so that's another question. Are other defendants being treated the same? That sounds right. So, right. Are only defendants offered a speedy trial? Well, that's a great question. And no, only defendants are the ones that you typically see fighting for speedy trial issues. Typically because speedy trial is a way to keep, you from being in jail. But technically the state also, or the government also has a speedy trial right. Monetary contempt, right. Okay. Judges are scared of MAGA. Well, I could be. Not just delay, he keeps posting and speaking against witnesses. Well, right. So, all right, so we have this delay issue, which is kind of undermining. It seems like what I'm seeing from the chat here is that it's undermining our judges. So through this delay, our judges are undermining themselves by delaying stuff, or for allowing for the delays. Like, why are these judges permitting this kind of conduct to go on? That's kind of the feeling that I'm getting here as our final course as to why we're struggling here. And I mean, right. Okay. Yes, yes, yes. Okay, excellent, excellent. So, and again, I'm just asking this because I'm trying to figure out which direction we're all coming in from. Make it a bench trial. No, no, no. You have an absolute right to a jury trial. Absolute right. Okay. All right. So, right. So we've got Cannon, we've got Chutkin, we've got McAfee here, and then we are in Merchan's court right now. All right. So these are our 4 Trump cases. So we have 4 Trump criminal cases going on right now, and we're feeling like this delay being allowed by the judges is undermining their ability, right? So let me just pose one more question then. Let me pose this question to you. So what if I was to, and we'll just have a moment here. What if I was to tell you that Mr. Trump's cases are actually going quicker than most defendants? That they're actually processing his appeals and his interlocutory appeals and his paperwork quicker than the average defendant. What would your thought be then on that? Although it seems like we're delayed, but the answers are actually coming faster than a typical defendant. Would you be surprised? You'd like to see him sentenced and incarcerated before the election. Fair enough, fair enough. Most defendants are sitting in jail waiting for everything. Well, right. It doesn't seem like it. Absolutely, Olga. It certainly does not seem like it. It certainly does not. You would be surprised. You believe it when you see it. Okay. Seems like a lot of cases have been pushed back, though. Right, right. Okay, only because he's the ex-president. So I think one of the things, okay, fair enough. Now, I'm not going to say that that's necessarily the case because we have 2 states cases, we've got 2 federal cases, everyone. And I'm just not going to come in and say in each of these jurisdictions, a defendant exactly like this would be treated, worse or less quickly or more quickly. I'm not going to say that because I do not know that as facts. But what I would say here is, a couple of things to think about here is every single case that's going through in all of these orders, what should the courts do? What should Judge Chutkin have done? Should she have not have paused that gag order for 4 days? Should she have kept it in place? Because there was about 1 or 2 sentences that the appellate court struck. So if she had not delayed it, what would have happened? If she had kept it in place, it could have been completely overturned, right? So should she have not have delayed it? Is that keep it in place? Keep it in place, but there was a line that was unconstitutional. There was a sentence in her order that was unconstitutional. Urgency is the election, right? Right. Well, I think it's good to just kind of bounce these ideas around, while we're kind of hashing it out. We're trying to figure out what level of frustration we're at and what's causing it, right? Right. So that's my other question. Now, Judge Cannon, I have nothing to say that's going to say she's the greatest judge ever. It's just not true. But she's definitely, plodding her way through this case, and it's a mess. It's a mess, and I think most of her cases are messes, in my opinion. If you look at the rest of her docket, they're also messes. Judge Merchan, I think he's clipping it along, and then Judge McAfee is got 50,000 cases going in Atlanta, and he's plugging along too. So they almost had a speedy trial as well. So I would say, I think, and the feeling I'm getting is really this kind of gag order issue out of DC. But is that enough then to say that Judge Merchan's order that he issued today, he's not going to enforce? Is this delay of the gag order enough to say, well, Judge Cannon's slowing things down. We haven't heard out of Georgia. That whole hearing was ridiculous. Chutkin's gag order, so now it must be then, Merchan, this order is not going to be valid. President, possible future president. Oh my gosh, I know. It's painful. I think we also have another situation that we're not really talking about, and that is how much went down in the civil case. treat him like everybody else, not with kid gloves. I agree with that. And I think that there are some kid glove moments that are occurring. I really do. I think, there have been several instances where I've been like, I think he's definitely getting treated better than your average defendant. I cannot say that there haven't been moments like that, for sure. For sure. 450 to 175 felt so unfair. Well, right. Such quickly they can rule if they want to. True. We would have been in jail for sure. Well, we don't know. We don't know if we would have been in jail. Court cases are, maybe, they're not, they're BS. I'll believe it when I see it. Fair enough, Olga. And I think that's fair. I think at this point, what I would say with this order is, let's see what Mershon does. Let's see what he does. We haven't had a chance to really see Chutkin in her full form because she was just clicking along, setting the dates, setting them up, knocking them down, and then we got stuck up on this immunity issue. So we were pretty okay with what she had been doing, I think, up until the Supreme Court situation. McAfee, again, I think we're all kind of burnt out on what happened with D.A. Willis and how he ran the show there. And so I think we've got some questions now. And Judge Cannon, again, is so, in my opinion, lacking so professionalism that it's hard to trust what she's going to do is going to be the right thing. And with Juan Mershon, I think we got to give him a chance. We got to wait for it. For me personally, what set me back with Judge Mershon was all the way back in the fall when he said, I'm not going to deal with this for 6 months until February. That for me was a bit of a red flag. But when I saw him pick the case back up and hit the ground running in February, I thought, okay, well, we're back at it again. So, I'm in a moment with this order when he is saying we don't have enough in fines. We have to use incarceration as a way to get compliance. I want to see if it's going to come true. Kid Glover goes to the left. Has money judges. Well, okay. Bye. The other judges are scared and timid. Well, I think, we got to follow the rules, right? We got to follow the rules. But I think everybody's got legitimate concerns, everyone. I think everybody's got legitimate concerns. I think we're all getting burnt out. I think it's frustrating. I think when we see these delays happening, we're like, gosh, can't we just get it done because we want to get it over? But one of the things about the legal system is that it's just this slow, grinding, marauding process, and it takes a while, and there are mistakes, and there's things that have to be fixed. Cannon set out an order regarding jury instructions that was ridiculous. Meanwhile, Jack had to come in and say, reconsider your order, and she did, and she set it out, and she's like, well, no, I'm not. So Chutkin's like clicking along, we need to go to trial, and then meanwhile, there's this appeal on immunity, and she's like, well, never mind, we can't go to trial yet. So it is frustrating, but I don't think we can throw all of our judges out yet. I don't think we're at a point where our judges are bad yet. I don't think we're there yet. That's kind of what my point was. And when we're walking through it, it's like, well, let's really break it down. Let's go a piece at a time and take a look at how each of these judges are, frustrating and what's causing us to doubt the ability of our process here. The other thing too is a lot of people do not understand all of the intricacies of how many times you can appeal, what can be appealed, and what cannot be appealed. That is something that is a bit unique to Mr. Trump and other people, piranhas, who are out there. That may not be the right word, but people who are in the system, know how to use the system, know how to work that system in a way to use it as a weapon. And Mr. Trump has that knowledge, and he has had attorneys in his life, all the way back that have used the system. They are the exceptions. They are the ones using every single step along the way to cause harm rather than to use it as a shield. So, and that's what I think Judge Mershon is saying here too. Mr. Trump uses the legal system. And most people don't use it to harm other people, but he does. And so we're seeing these tactics and what they can really do. Before, it was just oh my gosh, people are getting hurt by Mr. Trump because of how he's using the legal system. Now we're seeing like we're getting hurt because he's causing these delays, and the judges, they got to follow the rules. Yeah, yeah. So yeah, I mean it's frustrating, and he had one of his attorneys, I think he passed away, but one of his attorneys, I don't know if it was his dad's attorney or not, but there are some attorneys in the field who know how to twist everything up and kind of go down the dark road. It doesn't mean that they're doing anything illegal. It just means that they're being, jerks about it. Big jerk faces. Now, if you get one of those in 100 people, it's annoying. But if your entire life, like Mr. Trump's, is to be that jerk, it's like everyone around you is going to be frustrated with you. So I think that's definitely, yes, I think so. I think that's his name. Yeah, exactly. So it's been very frustrating. It's been very frustrating. At this point, so I'm not trying to cheer on our judges here, everyone, but what I am saying is that this is a really, really strong order. This is the strongest order that I have seen come from a judge for Mr. Trump, other than the E. Jean Carroll case, when Judge Kaplan came in and denied a new trial and said, "You are out of your mind and you are terrible. You're a bad person on the inside where it counts, and you're not getting a new trial." That's the only other order that I've seen come to this level with Mr. Trump. For sure, for sure. Yeah, I mean, I think we are really, if nothing else, we're learning from this process. We're learning how can these appeals be done? How are our procedural rules working? Are they really working the way that they're supposed to? Because we need to make some changes. And if you think that we're not sitting around and getting together as attorneys thinking like we need to change some of these deadlines or we need to change some of these ethics rules, you are mistaken. I have never had as much contact when it came to questions about ethics and ethics rules than I have in this last year, everyone, legally. I mean, it's just everything is getting revamped. So he's definitely making an impression in how we can make it so people can't use a system like this to hurt other people. Two sets of rules, where there's one set of rule, and I think that's a great way of putting it, actually, to look at it. So it seems like there's two sets of rules, but there's one set of rules, and then there's the rules that everybody follows, and then there's the rules where you go and you dig around and you find something just to use and abuse in order to better your cause. It's the same set of rules. You could use the same delay processes if you wanted to. It's just most people don't, because you go in, you take care of business, and you get out. You get out. You don't use it to actually cause harm, and that's just not Mr. Trump's way. Yes, so the order here we have is this is the finding of contempt. We have finding of 9 counts, so $9,000, and then we have a warning saying here incarceration will be our next stop. Almost can't. I know. It's frustrating. It is frustrating, but the rules are there. The rules are there. All lies are about rules. We're studying. Well, I mean, I don't know if you. I don't know. One of the best ways I can think of it is let me ask you this. Let me just. This will be my last point to ponder, everyone here to work through this. Standards, right? So, has anyone read? Does anyone have? Okay, don't answer this out loud, but just think to yourself. Do you know anybody in a public school system or a private school system? All right. So, K through 12. Just think in your mind. You don't have to answer. When you have a certain school that you go to, have you read the code of conduct? Have you read through that? Like, it's just read through all of what the rules say in the code of conduct, every single word in the code of conduct. So if there are any violations of the code of conduct, most people are like, wow, I had no idea that this was a violation of a code of conduct. I had no idea. Meanwhile, the people that have read it, can go and do whatever they want to do up to the actual line, up to the line, and then say, this does not violate the code of conduct on page 7. Have you read that? That's kind of what we're dealing with here. So it's the people that have combed through word by word, moment by moment, in order to use everything to their own advantage. Now, I will admit myself, of course, I've read all of the codes of conduct. And I read that just to make sure that I'm not violating any rules. I don't use it because I want to make sure that I can hurt somebody else by knowing what the rules are. See the difference there? And when I think that there are rules that aren't good, then you get on the committee to change the rules. So that's really what's going on here, is that we all have the same rules. It's just nobody's read the rules. And Mr. Trump is using the rules rather than to, protect himself. He's using them to hurt other people. They don't let me out of a speeding ticket because I didn't see the sign. You're absolutely right. You're absolutely right. Right, you're absolutely right. So I think that the other thing, too, to consider as I continue on with that metaphor, everyone, when you are going through school, let's take it back into school again, and you have one person who is incredibly wealthy, a kid in high school who's very wealthy, well-known, successful in high school, one of the popular kids, and they decide to violate the code of conduct. Are they going to be treated the same way as the kid that's all, not, that's the opposite, that's struggling, that maybe has some other issues going on? Are they going to be treated the same way by the principal? Right? That's the other question. So that's the thing. We all have the same rules. But if you're the popular kid or you're the outcast kid, there's going to be a difference in how you're being treated. And is that a two-tiered system of justice? No, that's just reality. That's just how life is because of how things are enforced. Now, the extent and where you live, those are things that you can change depending on what's going on. They won't be treated the same, right? And that's why there's so much anger in America. I agree. I completely agree. That's what we need to fix. And I don't disagree with that. I agree. I think it should be fixed. I think that there's a problem and it's something that needs to be addressed. But if there's a problem, you acknowledge the problem. The first step is acknowledging that there is a problem, right? And then the next step is forming a plan. So again, I would just relate this scenario loosely to our legal system as well. It's not like we're setting this up in order for, for everyone to be shut down and kept, away from justice. No, it's that if you're an outcast versus one of the popular kids, you're going to be treated a little bit differently. And, that's not right at all, and it shouldn't be that way. The closest we're ever going to get to being treated equally is going to be in a court of law. But other than that, it's a difficult situation. You never know, Thomas. You never know. If you fell asleep in court, would you be held in contempt? You never know. You just never know. I've seen people who have screamed at a judge and not been found in contempt, and I've seen other people who have begged for another 2 weeks because they hadn't gotten paid yet and put into jail for a week. It's really difficult. He's not being, I don't know, discrepancy in the legal system, those have money that have not. Well, I don't think it's a two-tiered system. I think that's, I don't know. It's moments like this where I remind everybody of the Mayflower Compact, right? Let's go back to the Mayflower, shall we? Right? So I cannot change the fundamental principles of the Mayflower Compact that set out those with privileges and those without privileges. All right? That's the kind of the nature. The rich and the poor. Well, right. I don't know that that's too tiered. I guess maybe I'm just thinking of rich and poor as not a tier system, right? There's this and then there's this, right? I don't see it as tiers. Oh my gosh. Right. The haves and the have-nots. I guess so. I guess so. It's not broken. I tell me, lovely. Tell me where it's not like that in the world. That's my other question. That's my last question. Where is it not like that? Tell me where it doesn't work like that so that we can use their system. Let's change the system then. Let's change the system. White collar, blue collar. Exactly. Oh my gosh, exactly, right? Exactly. Exactly. But where is it not like that? Tell me in the world. Tell me in the world that we live in. It's been, I think, Thomas, that's very accurate. Doesn't make it okay. I agree. It's not okay. It's not okay. But I think by figuring out how it works, you have a better, easier path of navigating it. Norway. All right. That's an excellent point with Norway. But Norway does have some problems, right? Norway has its problems. If you take a look at the system in Norway, and also if you take a look at the number of people in Norway, a lot of people pull in the Scandinavian countries when they give it good examples. But there are some other issues going on in those countries as well. But I think, if we were to pick one of the top systems, we could take a look at that. How could we implement the Norwegian system of justice here? Right. Right. Yeah, I mean, how Scandinavian countries still happiest places to live? True, absolutely true. I cannot deny that. I cannot deny that for sure. Well, the one thing I would say with Norway, again, I'm not going to with any of the Scandinavian countries, is that I think you still have this haves and have-nots type situation, but it seems like they're doing better than a lot of other places. But I can't tell you, have you, like for example, in Sweden, have you taken a look at how the indigenous people in Sweden are treated? That's a question to ask. What's happening to their land in Sweden? What's happening to the indigenous tribes' land when it comes to what the government would like to do to help its people versus the homeland of the indigenous peoples? So we've all got questions like that, right? No, indigenous just means that they've been there the longest, doesn't it? Isn't that what that means? Better prison system. I would say our prison system is awful. Our prison system is absolutely awful. It's not possible to be perfect. Why try? I would say maybe just acknowledging, that there is no perfection, to work with and continue to make better what we have. I would say. I would say. No, I think you have to know the game you're playing so that you can make it better and figure out how to do better rules. That's how I look at it. Mm-hmm. Tied to the land. Yes, exactly. Exactly. Netherlands has ageism problems. Yes, indeed, indeed, indeed. All men are created equal. And that's one thing about it, Mr. Dude? That's one thing that we've done. I think our PR in the US, our public relations was amazing. And I think we're all getting a little bit of a reality check on, like we really believed our rhetoric. But if you peel it back, if you look back, there are a lot of things that we kind of have talked ourselves into, I think, over the years. And that doesn't make it wrong. It just makes the reality when we are like, ooh, that's not quite right. It's like coming out of the matrix. Like, ooh, oh, that hurts. But, I think I don't see this as a negative thing. I think every day when we learn more and we figure things out, I think is good. We're going in the right direction. I think as long as we just keep moving forward, we're doing what we need to do. Well, right, and that's a huge issue. History teachers growing up. Oh, I know, right. It's kind of been, we've kind of been spinning. We've had our own kind of, patriotic bit that has kind of gotten away from us, I think, in my opinion. But yes. we're not as exceptional as we thought. I think I think we are just so young that we are like, we're the greatest thing ever. And now we're like, ooh, yikes, sorry about that. Let's clean up the mess. That's in my opinion. That's my opinion. Now, don't get me wrong. I have to say, I am incredibly, happy to be an American. I will not move anywhere else. I'm very pleased to be here. Don't get me wrong. I just think that the level of patriotism that I think we all had, coming back after, the wars, I think is really kind of, taking us all for a side for a bit. So, yeah, we have work to do. I agree. So hopefully everyone, though, I appreciate you bearing with me as we go through these philosophical discussions here on what our judges are doing, what they're not doing, if they're going to be okay, if they're not going to be okay, how that's all going to work. I do appreciate that and talking with everyone about it because, I think we need to talk about it. I think we've got to be able to articulate what it is that's so frustrating, why it's frustrating, and then what we can do to work through it. Frontal lobe is trying to oh my gosh, Sloan, that's perfect. That's absolutely perfect. Oh my gosh, perfect. Yeah, we're young. Yeah, we've got some work to do, but again, I think there's a lot of, I pause for a moment and I think we've also done a lot of good in this country. There's a lot of good, but we're definitely going through a very painful growing pain moment here, but we'll make it through. So we'll see what happens, everybody, when it comes to, they really are painful, Jennifer, I agree. When the Thursday hearing comes up, we'll see what happens. Again, we've got our two roads we can go down, depending on how Judge Mershon wants to view the timing of everything based off of this order. So yes, thank you very much, everyone, for joining. I really do appreciate it. This was fun to kind of go through this order and talk about it and kind of work through, we're all kind of in the same boat here and we're all a little bit frustrated and would like to see, the right thing, what's appropriate, go down here, especially when, everyone's supposed to be treated the same. So we're going to get there. I think that will happen for sure. Love your life. Thanks. Oh, thanks. Oh, Bessie. Oh, thank you so much. Oh, you're so sweet, everybody. Oh my gosh. You're so sweet. Stop, everyone. You're so sweet. So this will be my life for today. I will be back again tomorrow. I'll make a post for sure in the morning and let you know when I'll be back on and what the topic will be. But this will be my post for today. I need to go and kind of rest my voice. So it was great chatting with all of you. Thank you for all of your comments and questions. I really appreciate it. I always love to see all these different perspectives on everything. And kind of figure these things out together. So have a great rest of your day, everybody, and have a really good night. I'm planning to have a very nice night tonight. So I'll see you all tomorrow. Take care, everyone.